right, if everyone's settled, Mr. Holtzblatt?
May it please the Court. Confronting Tesla's innovative direct-to-consumer business model, Louisiana's auto dealers could have tried to compete in the market on the merits. Instead, they used their control of the Louisiana Motor Vehicle Commission to try to drive Tesla from the state, and they hid behind state laws whose sole and illegitimate purpose is to insulate franchise dealers from competition against non-franchising automakers. The Sherman Act, due process, and equal protection together bar these efforts to appropriate state power to eliminate competition. Now, Tesla's claims should not have been dismissed. Now, I'm going to start with an overview. Take first the Sherman Act claim against the dealer commissioners in particular. Their multiple votes and financial interest against Tesla alone suffices to plead agreement. State action immunity cannot shield them, which they do not dispute on appeal. And for the dealer commissioners, Norr Pennington is irrelevant because the dealer commissioners could not possibly petition themselves. As for Lada, it does not dispute agreement on appeal, and Norr Pennington does not protect conspiracies like this one among competitors using their own unsupervised government power to restrict competition. The second claim, Tesla likewise stated a due process claim, also against the dealer commissioners. Due process guarantees a neutral adjudicator, not one tempted by financial self-interest, as the dealer commissioners are here. And third, on equal protection, this circuit's case law instructs courts not to dismiss unless you can find a rational basis on but momentary reflection. Here, even an hour's reflection would not uncover a potentially rational basis for Louisiana's direct sales and servicing bans other than raw protectionism, which this circuit has already deemed impermissible.
Okay, you've held your press conference. Now let's get to some of the law. Tell us about antitrust injury here. Where is it and what is it?
Thank you, Your Honor. Tesla alleged paradigmatic antitrust injury, that is, harms that the antitrust laws aim to prevent. Number one, they alleged an agreement that would exclude Tesla from performing warranty services or leasing in Louisiana, and that has deterred other direct-to-consumer manufacturers from entering Louisiana. That harms consumer choice, it limits services, and it increases prices. Now, defendant's primary counter argument is to claim that Tesla only faces investigatory costs from responding to a subpoena, but that's not what Tesla alleged. Just to give one example, at paragraph 158 in Record on Appeal 1612, Tesla alleged that the dealer cartel had agreed to bar Tesla from providing warranty service on purchased vehicles. That's not in dispute on appeal. At pages 12 and 33 of the commissioner dealer's brief on appeal, they admit, yes, we believe that Tesla should be excluded from providing warranty service on purchased vehicles. That agreement excludes Tesla from an important part of the market because warranty services are critical to Tesla's ability to serve its customers, and if it couldn't provide them directly, it would raise Tesla's cost to do that. The votes on the subpoena here were admittedly, by my friends on the other side, an agreement to at least to stop Tesla from doing that. So that's the first part of antitrust injury, Your Honor. Tesla also alleged that the dealer commissioner's harassment will discourage them from leasing Teslas. In fact, if Your Honor looks at Record on Appeal 119, you'll see the subpoena that was issued in this case. The first item relates to servicing, but the second relates to leasing. So there's no question that the issues that were raised in this case address leasing as well, and all of this deters other direct-to-consumer manufacturers from entering the state. Cutting off direct-to-consumer manufacturers that have a distinct business model from entering the state is classic harm to competition that the antitrust laws were designed to prevent. Now, the antitrust laws are clear, Your Honor, that Tesla does not need to wait until it is driven from the market before it can bring its antitrust claims. Competition is fragile, Your Honor, and it is important that Tesla be able to bring its claim once the agreement has been formed and the harm is clear, and that is the case here, Your Honor. So we've talked about antitrust injury.
Okay, what's the status of the state court proceeding?
The state court proceeding is there has been some motion practice before the state court proceeding, and nothing at the moment is happening in the state court proceeding.
Okay, I'm just struggling a little bit about why are there two cases? Why are you challenging the subpoena in the state court and coming to us on these issues?
Well, thank you, Your Honor. The state court proceeding is, first of all, completely irrelevant to Tesla's antitrust and equal protection claims. Federal courts have exclusive jurisdiction over antitrust claims, so our antitrust claim is not a claim.
Well, but your argument is that their investigation of you all is the problem, because that's really all they've done is investigate y'all, or they're trying to. So if the state court throws that out, what's left?
Well, our argument is slightly different than that, Your Honor. Our argument is that the votes as part of the investigation are evidence of an agreement, but it's the agreement to exclude Tesla from the market that is what establishes the antitrust claim. That is a claim that we could not bring in
Right, but then
in
why
state
didn't
court.
you bring the whole thing in the federal court?
Well, we couldn't challenge the subpoenas under state law in federal court. What we can challenge in federal court are federal claims. The antitrust claim, which
You
federal.
don't think that could be a supplemental issue?
I'm not sure it could, Your Honor. But in any event, federal courts, of course, have an unflagging obligation to decide federal claims that are within their jurisdiction. That is certainly the case for the antitrust claim, for which federal courts have exclusive jurisdiction. Our equal protection claim doesn't challenge anything regarding the investigation. What it challenges is the direct sale and servicing bans, which we also aren't bringing in state court. And that leaves, I think, the due process claim, which has some overlap with the issues that are presented in state court.
But I just want to make sure I understand your argument on this. If they were told they cannot do the investigation, how would they be able to do anything more against y'all?
Well, what we've alleged in the complaint, Your Honor, is that this is an agreement to exclude Tesla completely.
No, I understand that's why they're doing the investigation is your position. Okay, I get that. But if they can't do the investigation, then they can't prove that y'all are doing what they think is wrong. So then what's next? That's why I'm just trying to understand why that isn't potentially dispositive.
Thank you, Your Honor. The investigation is broader than just warranty servicing, which is the basis on which we've argued in state court that the investigation has to be cut off is that the Tesla is a fleet owner. The commission has, quote, no authority over fleet owners. And so that's the argument we've made in state court. Now, the subpoena, as I said, at Record on Appeal 119, makes clear that the scope of the investigation is not limited to warranty servicing. It also reaches leasing activities. The subpoena seeks information about leasing activities, and at least I haven't heard my friends on the other side argue that if they were cut off from investigating Tesla for its warranty service activities, they also would have to stop investigating their leasing activities.
I thought the warranty was connected to the leasing.
There is a connection, but what we have, of course, alleged, Your Honor, and on a motion to dismiss, our allegations have to be taken as true, is that the agreement is to exclude Tesla not only for its warranty service activities, but also for its leasing activities.
But they officially disagreed with the AG on that, the Attorney General, on can y'all do what you're doing?
Well, Your Honor, they have disagreed in...
I.e. have a leasing.
Yes, Your Honor, we have... We of course have alleged that their disagreement was pretextual, and we think that allegation of pretext has to be accepted as true at this stage because the letter itself admits we're worried about antitrust liability, so of course they're going to publicly purport to disagree. But in any event, at this stage of the case...
I mean, if I say I'm going to follow the law, is that a negativity on my part that I'm following the law?
Well, Your Honor, no, Your Honor. If active market participants who have the ability to exclude competition agree to undertake efforts to exclude competition, the leading proponent of the direct-to-consumer business model, that creates an agreement that is cognizable under the antitrust laws, which is what we've alleged here. Now, I think to the extent that Your Honor is I think, speaking to our abstention questions, which is, I think, the only basis on which this court, federal courts could choose not to take up federal claims which are within their jurisdiction. No party has raised abstention on appeal, which I think is a strong reason not for the court to stay its hand as a result of abstention. Certain abstention doctrines are waivable, and even those that are not, it's inadvisable to take them up when.
I'm just trying to understand. I'm not necessarily saying that should be raised here. I just don't. It's just a little bit odd to me trying to figure out exactly what it is that they're doing and why that isn't something that you could have more fully addressed in the state court, or taking the state court stuff here so one court would be addressing it.
Well, I think there are state law issues that we're pursuing in state court. There are federal claims, our antitrust claim, over which the federal courts have exclusive jurisdiction, and we think these are critical questions. Now, as the Supreme Court said in North Carolina Board of Dental Examiners, these types of agreements by unsupervised market participants to exclude competition present a serious structural risk that the dealer commissioners will confuse their own interests with the public interest, and for that reason, it's critically important that there be a place for the antitrust laws. The federal court is the only place we can bring our antitrust claim, and what we have here is an agreement which is evidenced by the multiple votes that the dealer commissioners took to exclude the leading proponent of the direct-to-consumer model, which is designed not only to exclude Tesla, but also to dissuade other direct-to-consumer manufacturers from entering the market in the first place. That is classic harm.
You agree, I assume, that in this circuit, the mere threat of decreased competition isn't enough under the antitrust statutes?
We don't have just the mere threat of decreased competition, Your Honor. What we have is an agreement to exclude Tesla from the market with respect, at a minimum, to providing warranty service on unsold vehicles, backed by the ability of the commission to impose $5,000 fines per violation or to potentially revoke Tesla's license. They have already told us in their briefs, this is our view. Just no different from in the North Carolina Board of Dental Examiners case or the Smile Direct Club case, where there was an agreement by a board that was controlled by active market participants. Their view in those cases, the boards in those cases, their view was that the non-dentists were engaged in the unlawful practice of dentistry by, in North Carolina, providing teeth whitening services, in the Smile Direct Club by providing teeth aligning services. In all of those cases, the board said, well, we think what we're doing is authorized under state law. It's something that we can pursue by voting to take action against the innovators in those cases. We had agreement that stated a claim, and we think we've got that very much here directly.
Focus on the 2017 statutory amendment and summarize for us what you think you were able to do or not do before then, and what you were, how that was changed, if at all, by the 2017 amendment.
Thank you, Your Honor. We have a long footnote in our brief where we explain that prior to the 2017 amendment, we believe that the non-franchising manufacturers were permitted to sell vehicles directly. That language was struck in the 2017 amendment, and if you look at the news coverage and the statements of the sponsor, all of them described the change as a modification. Well, if it's a modification, it was a modification to remove the ability of non-franchising manufacturers who could sell before directly and now cannot sell. But even if the court were to disagree that that's the effect of the 2017 amendment, we've asserted our equal protection claim. There was a point in time, we've pointed to the 1999 amendment, which added language that my friends on the other side claim already banned direct sales, and in the 1999 amendment added the language that they say expanded it from franchising, only applying to franchising manufacturers, to expanding it to non-franchising manufacturers. And whether we look at the 2017 amendment or the 1999 amendment, as the Sixth Circuit said in the Craig Miles case, you cannot graft an irrational change in the law onto a law that might otherwise be rational in order to save it from equal protection challenge, which is certainly what we have here. And we've addressed many of the proffered explanations for applying the law to the direct sale ban to non-franchising manufacturers in our brief, but there is nothing other than raw protectionism that could justify excluding non-franchising manufacturers who have no franchises that need to be protected from competition. Now, I do want to make sure that I address our due process claim here, because I think our due process claim is critical. The due process claim ensures that Tesla have a right to a neutral adjudicator, not one that is skewed by a significant financial stake, as the dealer commissioners are here. And that is the problem that we have in this case. Now, this is precisely the kind of pecuniary interest that the Supreme Court addressed in the Gibson and the Wall cases and forbids. A board that is controlled by businesses committed to one business model cannot fairly decide whether its competitor's competing business model is lawful. Gibson and Wall, that was boards of independent optometrists that were trying to shut down commercial optometrists. Here it's franchise dealers who are trying to shut down non-franchising automakers. The principle, though, is the same, which is that Tesla is entitled to a neutral adjudicator. Now, the dealer commissioner's primary response is to point to this court's decision in the Chrysler case, but in that case, the predictors of bias pointed in opposite directions. That was adjudicating a lemon law, and what this court said in the Chrysler decision was that the dealer commissioner board had just as much incentive to side against a rival dealer when it was adjudicating the lemon law, because it would harm a rival among its dealers, as it did to side with the manufacturer. And so the bias concerns might have pointed in both directions, but here they point in only one direction, and that's against Tesla. The commissioners also argue that Tesla must allege that the dealer commissioners in fact acted out of their financial interests, but that is not what Gibson and Wall say. They require a substantial pecuniary interest, and so the financial temptation alone offends due process.
How do y'all have a claim against the 3 public members of the commission?
Well, we thought we had a claim when we filed the case, Your Honor, because we needed to ensure that, and certainly with respect to the due process claim, that the judgment of the court would hold, but we're not, we want the core of this case to move forward, and so if the court disagrees with us, we're not going to object to the court dismissing the public commissioners. Certainly the dealer commissioners have this financial...
Aren't they the ones who would be deciding the case, if you will? If they, after the investigation, if that found something, aren't they the ones who would decide if there was some issue?
Well, I'm not sure they would, Your Honor, but we have the bias has already manifested itself at this stage of the proceeding. Tesla asked the dealer commissioners who adjudicated the subpoena to make a finding that Tesla was a fleet owner, because if Tesla is a fleet owner, then the commission has no, quote, no authority over it with respect to the only subparagraph that prohibits Tesla from engaging in warranty service operations, and the dealer commissioners declined to do that and voted to proceed.
So if y'all are violating Louisiana law, you're saying that the Attorney General is the one should be getting you investigated?
Someone other than the body of active market participants who are unsupervised by any disinterested official and who don't have a disqualifying financial interest has to be the one to violate. The Supreme Court has repeatedly recognized that boards of this sort create very severe antitrust problems and very severe due process problems, and the solution, and they especially create those problems. This is almost exactly what was presented in North Carolina Board of Dental. It's almost exactly what was presented in Gibson and Wall, and the solution in that context is to have someone who isn't burdened by that self-interest and that desire to exclude competition to be in charge. Now, and I'll give you, Your Honor, an example. There was an earlier case brought by Nissan against this very commission when the commission was structured differently. It didn't have the 3 non-licensee commissioners at the time, and the district court found that there was the due process problem under Gibson and under Wall, and enjoined that case from going forward. Well, after that occurred, Louisiana changed its law to add these 3 public commissioners. So Louisiana is wholly capable of adapting its system to ensure that these very severe due process and antitrust problems do not persist, and that's all that we ask here. The Louisiana is free to organize its government as it wishes, but when it does so, it has to conform that organization to the strictures of the Due Process Clause and to antitrust. Your Honor, as I've already said, I think this case is really on all fours with North Carolina Board of Dental Examiners and with Smile Direct. And some of the arguments that my friends on the other side have made about why those cases should be distinguished, I think really would be an end run around the strictures, for example, on state action immunity that the Supreme Court set forth in North Carolina Board of Dental. And it would also confuse the requirements of agreement, which is really just that separate decision makers within the market have chosen to come together to make that agreement. And as Judge Wilkinson explained in the Robertson case, I think that is easily demonstrated by the votes themselves. The justification for that agreement is not something that should be addressed under the agreement. That really goes to a different element of the antitrust laws, which is whether or not this was an unreasonable restraint of trade. Now, of course, Your Honors, we believe that Tesla is a fleet owner, and as a result of being a fleet owner, it should be allowed to engage in warranty service operations here. We don't think that it directly bears on the antitrust questions that are presented, but it's certainly not a reason for the court to not rule in Tesla's reverse this case and allow this case to go forward to discovery, which is critical to ensuring that these principles of competition and that neutral adjudication are allowed to proceed. Now, lastly, Your Honor, I do want to make sure I address Lot. Your Honor.
Well, I was just going to say, wouldn't the discovery allow them to do the investigation that they've put on hold?
Well, they may pursue those questions in discovery. I think there are really important questions that we need to be able to develop in discovery, including, we have the burden the pleading burden on agreement, for example, is not the same not the same burden at summary judgment. And I think we have certainly established that a reasonable likelihood that further discovery will demonstrate agreement, but I think there is more that we would obviously develop in the course of discovery on the agreement question and communications. We filed a public records request with the Commission and obtained a surprisingly small number of documents. I mean, Commissioner Crakey said we've met repeatedly over the course of 5 years, but we've got only a handful of the communications that were produced in those public records requests. So I think there's very important questions that need to be addressed in discovery, and I see that my time has expired, so I will reserve it for rebuttal. Thank you, Your Honor.
You've saved time for rebuttal, Mr. Holtzblatt. Thank you. Mr. Mandelberg for the Department of Justice.
Your Honors, and may it please the Court, Matthew Mandelberg for the United States. We appreciate the ability to be here today to address the correct legal interpretation of Section 1, which could affect more than just this case. The District Court erred at pages 46 and 47 of its opinion when it indicated that a Section 1 violation requires a purpose of unreasonably restraining trade, what we have termed an anti-competitive purpose. As explained in our amicus brief, this is a mistaken view of law, and significantly, the defendants do not claim otherwise in their briefs. We urge this Court to correct that erroneous statement of law when issuing its decision. When pleading a Section 1 claim, there are two central elements. First, concerted action, and second, unreasonableness, and neither requires an allegations of an anti-competitive purpose. For the first of these elements, the Supreme Court decision in American Needle makes clear, concerted action is any action that joins together separate actors and deprives the market of independent centers of decision-making. And because this element is satisfied even by pro-competitive concerted action, an anti-competitive purpose is not necessary. And for the second of these elements, anti-competitive purpose is similarly not necessary to establish unreasonableness. Some forms of joint conduct, like price fixing and market allocation, are per se unlawful. And for conduct subject to rule of reason analysis, unreasonableness can be shown through an anti-competitive effect alone. And even though this only arises in the District Court's alternative holding, we care about this issue because it's important not to superimpose additional requirements on top of the required elements. As I said, this could affect more than just this case, including other cases brought by the government. And thus we ask this court to make clear in its decision that alleging an anti-competitive purpose is not necessary to state a Section 1 claim.
You're not recommending a result here, but only a clarification of the law as stated by the district court. Is that fair to say?
That's correct, Your Honor.
We appreciate your request to participate and your being here to assist us as officers of the court.
Thank you very much, Your Honors.
Mr. Clement?
Good morning, Your Honors. May it please the court, Paul Clement, and I'm representing all of the appellees here today at the podium, and I'm joined by counsel table by my colleagues who are representing the government entities as well. Nothing prevents, Your Honors, Tesla from selling its cars and having them serviced in Louisiana in the same manner that other manufacturers have employed for decades. But Tesla prefers its direct sales model and wants Louisiana law to yield to its preferred business model. In this regard, Tesla's principal beef appears to be with Louisiana's legislative direct sales ban. But on appeal, they have preserved only one challenge to the direct sales ban, an equal protection claim that, with all due respect, is squarely foreclosed by this court's precedents and decades of post-Lochner decisions, making clear that companies have no constitutional right to pursue their own preferred business model. A state can lawfully decide it prefers to promote intra-brand competition among dealers rather than allow manufacturers to have a monopoly on the sales of their own vehicles within a state. Tesla's remaining claims address not the direct sales ban, but alleged antitrust and due process claims concerning Tesla's ability to service its own leased vehicles and other Teslas that it does not own. On these servicing issues, Tesla's efforts to allege a conspiracy and due process violations face a substantial and ultimately fatal hurdle. The commissioners, in their official capacity, have rejected the lobbying efforts of the Dealers Association from having Tesla service its own leased vehicles. Having watched the commission side with it against the Dealers Association and the Attorney General on that major battle, Tesla is poorly positioned to argue that the commissioners are inherently biased against them or to allege a plausible commission-dealer association conspiracy to bar it from the leasing market.
I believe their argument is that that's pretextual and that they should be allowed to present evidence on that.
And with respect, Your Honor, I suppose that is their allegation, but I think allegations have to be plausible, a plausible allegation of an agreement. And I think, in the face of an effort that was supported by the state attorney general to basically say that Tesla can't lease even its own vehicles, I think to just allege that the disagreement then, the whole disagreement was pretextual, and the fact that they have a servicing center in Louisiana, in New Orleans, I don't, that physically exists. They are currently servicing cars at that servicing center, so I'm not sure how you can just say that's all pretextual. I think there are limits to how much you can just waive a pretext allegation and get around the basic Twombly requirement that your allegation of an agreement has to be plausible. And as to that, the one remaining area of disagreement, just to make sure we're all on the same page on this, is really whether or not, if Tesla qualifies as a fleet owner, which they do under the view of the commission, whether that means that they can then service all of the vehicles in the fleet that they actually own, which is the commission's position, or whether it means that once you're a fleet owner, then Katie bar the door, you can service any vehicle you want in the whole state. The Teslas that have been purchased in other states, or I think if you take their position to its logical or illogical conclusion, it would mean you could service every vehicle in the state. And that's the remaining bone of contention. As Judge Haynes has pointed out, that bone of contention is squarely presented in the pending state court proceeding. And
why would we have the two? I understand the point that the federal court is the only one who can decide part of this, but couldn't this federal court have taken as supplemental the issues before the state court?
I don't see any reason why they couldn't have, or, maybe there would have been an argument if they tried to do that. There might have been some abstention issue, but even then, I think the abstention issue would have only applied to literally the validity of the subpoena and whether it could be enforced. And to be clear about, I want to be clear about two things. I mean, first of all, there were state claims in the original complaint here. There were state antitrust claims, state unfair competition claims. So it's not like Tesla looked at this and said, we're going to bring all our federal claims in federal court and we're going to save our state law claims for state court. So they went out of their way to not bring any direct challenge to this fleet owner issue in federal court. And it goes even beyond that, because if you look at footnote 29 of their complaint, which is at Record of Appeal 1175, they drop this footnote in the course of their due process argument where they go out of their way to say, and I'm quoting now, Tesla does not ask this court to enjoin those proceedings or to issue any declaration on the requirement of state law. Rather, Tesla asked this court to declare that whatever the proper construction of state law, the commission is currently structured is not constitutionally fit to answer those questions consistent with due process. So it's not just that they didn't bring it. Like, they want this court, they want this court to decide the case on the premise that the commission might well be right about the scope of the fleet owner exception.
Why is the state court taking so long? Everybody keeps saying, oh, it's still pending, it's still pending. I mean, I remember being a state court judge. I was trying to get my cases done.
So I'm not sure I have the
Not in Louisiana.
Yeah, no, I understand. I'm not sure I have the perfect answer to that question. It may be sort of a byproduct of the federal lawsuit and the fact that this is sort of where the action has been. I also think, just in all candor, Your Honor, the state court proceeding is kind of at a weird sort of procedural posture, and I'm just not sure either side has a sufficient incentive to get the definitive determination of this question. That is my candid answer, but it remains pending. But I think what's so striking is I just, with all due respect to my friends, don't think Tesla can come into federal court and say, the commission might be right about the scope of the fleet owner exception and then still make their due process and antitrust claims.
Okay, but their due process claim is that y'all aren't able to ethically do the investigation. So even if the investigation is correct, even if you're not supposed to be doing any warranty services to cars you don't own that you were leasing, even if that's true, y'all shouldn't be the one doing it because y'all are not neutral.
So let me give you the doctrinal answer to that and then the practical irony that backs up the doctrinal answer. But the doctrinal answer is that's not right under the Supreme Court's decision in Friedman and this court's decision in Chrysler. What I read those cases to stand for is the proposition that you can no longer just point to one of these professional regulatory commissions and say, well, there are a majority of people on that commission that don't share my business model, and therefore they can't judge me as a matter of due process. That kind of structural challenge, I believe, is foreclosed by those decisions. Friedman, in particular, involved a commercial ophthalmologist, and there was a majority of independent ophthalmologists, or maybe it's optometrists. I've never been good at keeping those two straight. But there was the structural problem, the same structural problem they're asserting, and the Supreme Court said, notwithstanding those earlier Supreme Court cases that involved an as-applied challenge to a particular enforcement action, they said that kind of structural challenge is no longer viable. Then in Chrysler, this court rejected a claim against the Texas Motor Vehicle Commission where there was a majority dealer population on that commission. Now, to be sure, this court went on to say, well, there were kind of indicia in the particular dispute there that went in both directions. But I think here the most significant indicia of sort of objectivity or the ability to adjudicate this impartially is the resolution of the basic question of whether Tesla could be a leaser of its vehicles and service its leased fleet itself. On that issue, the commission sided with them. And then there's the practical irony I promised. On that, as the colloquy indicated, I suppose they think that the sort of solution to this would have the Attorney General then back the enforcement action. But of course, the Attorney General is already on record as against them on the whole issue. So I don't think they really want to have the Attorney General come in here and take over the enforcement of this. I would also say if you don't have this...
Well, and wouldn't it have been the 3 public members who would address that?
I don't know that that's the case, because this ultimately, I guess, that there's a possibility.
That was their purpose.
Their purpose is for a classic manufacturer-dealer sort of dispute over the scope of, like, the franchise law and how the manufacturer is treating their own dealer. That's the classic use of the 3 public members. That's the one
Well, that's because you don't classically have this situation that you're having with Tesla, but if it had come to that, if the investigation had gone on and had found things they thought were a problem, wouldn't they have deferred it to the 3 public members?
I'm not on the understanding that that's how they conceive the public commissioner's role. I think they really do conceive it as more limited. But I suppose if the question was, okay, we really think there's a due process problem now, the fact that there's something of a mechanism available internally to solve it seems to me something that, like, that might be a reason to not, like, an additional reason to not accept this kind of...
If we found a due process violation, the correct thing would be to defer it to the 3 public members?
It would be...
Throw the whole thing out?
Yeah, or to me, the way I think about it, that's an additional reason, in addition to what Friedman and Chrysler say, to wait for, like, the real as-applied challenge to take place. Because then there'd at least be a possibility for the commission to try to solve the problem in that way. But we don't know precisely what would happen. But this kind of ex-ante, more facial challenge, I think, is foreclosed by Friedman, is foreclosed by Chrysler.
Well, they're saying that the violation is the investigation, not just some sort of decision-making. So you're saying that can't be the case?
I'm saying that if that's what they want to focus on, that's different from the cases they rely on all involved enforcement actions. And those were the earlier cases, I think Mills. And then when the Supreme Court comes around later in Friedman, they basically say, we're not going to accept a structural challenge, and you can wait for that kind of enforcement action where they're really taking action against them. I don't think there's a case that says that you can't even, that the commission, especially given that it's already on the threshold question, ruled in their favor, that they can't even have a subpoena to determine whether the Tesla is obeying the law in the conception of the commission. To say that violates due process, I don't think there's any precedent for that. And to the extent it matters, the subpoena decision itself is made by the executive director. That's who initiates the subpoena request. Now, the commissioners, eventually Tesla challenged it, and the commission had a vote to say that they thought the executive director's subpoena could go forward. But the original decision here is made by the executive director. They haven't named her as a defendant, and she doesn't, she works there as, like, the professional staff, so she doesn't own a dealership. So I just think there are all sorts of problems with the due process clause and argument, and what I would say is, if you accept their view of due process, then I think you are intruding so much more deeply into federalism than if you sort of accept the precedents in Friedman and Chrysler, where on a kind of as-applied basis, if there's a real problem, then we'll find a due process clause. But here, Louisiana, as sovereign judgment, has decided that the enforcement of these laws is going to be done by this commission. This commission is actually structured quite differently from North Carolina Dental and some of the other situations. These are all gubernatorial appointees. One of these commissioners serves at the pleasure of the governor and can be removed at will. I know how important that is.
Some of them are competing dealers, right?
Some of them are competing dealers, for sure.
I mean, to me, as a matter of, obviously, plausibility is the standard under Rule 8. And you're well aware of that. And that's the stage where we are right now. It seems to me obviously plausible that there would be a conflict of interest. So you may find out more at summary judgment or at trial, but it seems to me that that's plausible under the standard that the Supreme Court generally recognizes.
So with respect, Judge Smith, I don't think it's plausible, given that the whole reason that there is a dispute about whether Tesla is obeying the scope of the fleet owner exception is because this commission has allowed them to service their own vehicles. So they are literally on the market today servicing their own vehicles, not just their lease vehicles, I think, but also the ones that have been purchased in other states. And the whole dispute here is that delta between the vehicles that they're servicing in their own fleet and the ones that have been purchased and are privately titled to other people. And given that they're on the market, and they are a licensee of the commission, and the commission has just had an inquiry as to whether or not they are complying with the commission's sort of view of the scope of the exception that the commission itself gave them, I mean, I don't think it's plausible to say that there's a due process problem. And I think, as I heard my friend earlier today, he seemed to be making more of this structural challenge, that the whole problem is just the membership of this organization. And I just read...
Your argument is that that's foreclosed by Friedman.
By Friedman, and I think by Chrysler. Because to me, if you're looking for indicia of an ability to proceed fairly, the fact that Tesla was granted the exemption and is on the market, and the only dispute now is the scope of the exemption, that seems to be a powerful indicator that this commission can call balls and strikes. So if I can turn then just a couple of additional points on the antitrust issues. So I think the fundamental problem here is there's essentially no plausible evidence of an agreement that includes the private actors and the commissioners. I read my friend, or I heard my friend, is almost conceding that today, because when he wanted to tell you about his antitrust claims, what he wanted you to focus on was just the commissioners in their official capacity. And I think that's because, as Judge Vance pointed out, if you look at this complaint, there's just nothing that sort of suggests that, particularly as to this leasing issue, there's anything going on with the individual commissioners in their private capacities or with the Dealers Association. And then as to the broader issue of whether Tesla can service its own fleet, whatever the scope of that is, like how could there be a plausible allegation of an agreement when there's a public disagreement between the Dealers Association and the Attorney General on the one hand and the commissioners on the other hand? So I think this case lacks the most basic requirement for an antitrust conspiracy. There's just not a plausible agreement here. Now, when they focus on the commission members in their official capacities, they are, as I read them anyways, asking you to do something that no court has ever done, and this court implicitly sort of suggested the opposite in the private standard-setting context in the Golden Bridge case, which is they want you to say effectively, all right, you can only have like a subpoena approved, or you can only have action if the commissioners in their official capacity authorize it, and that authorization vote itself, that's the agreement. So we got check. We got the first element of our antitrust conspiracy. No court that I've seen accepts that. They all essentially, in this kind of context where there's a legitimate government entity or there's a legitimate standard-setting organization, require something more than just the fact, well, you showed up and you all voted the same way, and there's the agreement. And there's just nothing more than that here as alleged in this complaint. And I think the Golden Bridge case from this court it's a standard-setting case, but I think it is parallel, because you had a situation there where you had, in a standard-setting organization, there was an organization that was, used to be on the sort of the secondary list for the standard setting, and then there was an agreement by the members of the standard setting group, like, you're no longer a part of the standard setting. And they sued the companies that were their competitors that voted ultimately to approve the new standard, and really all they could marshal was the idea that, well, you all agreed to set the standard hurt us, end of case. And this court rejected that claim and said there was no basis for the claim. Now, it was on summary judgment, but the legal principle that you established, I think, supports a motion to dismiss in this case. And I think, they want to point to the California Smile Direct case, and they want to point to North Carolina Dental. But in both those cases, you had much more that was part of the agreement. You had, in the North Carolina Dental case, you had a series of threats by the commission to use criminal enforcement power that the commission didn't even have. They were limited to more regulatory authority. In the Smile Direct case, you had a series of raids, and you had allegations of retaliatory sort of conduct. So I think in those cases, you had sort of plus factors, and so those out-of-circuit cases are distinguishable. And I think it's this court's Golden Bridge case that's directly on point and essentially dooms them at the threshold on the agreement. And I do think it's important. Part of the reason we didn't take any umbrage at the government's sort of site checking of one paragraph in Judge Vance's opinion is because it was plainly an alternative holding. And I think what she was in that paragraph trying to deal with is this idea that in these kind of contexts there has to be something more. And I think this court's decision in Marucci, which she cited, also stands for that proposition. It's not enough to say that the NCA got together and decided which bats go in and your bat didn't make the cut and okay, antitrust violation. No, you have to show something more. And the something more is just missing in this case. And again, I think my friend was wise to not try to make a claim about a broader conspiracy or agreement that included the Dealers Association and the dealers in their individual capacities as to this subpoena issue, because there's just nothing in the complaint to support that. Now, on the Equal Protection Clause issue in particular, I want to spend a minute on that if the court will beg my indulgence. I think that's the one case, that's the one claim in this case that really goes to what their real beef is, which is they're not selling directly in Louisiana. As to everything else they're complaining about, they're doing it. They have a service center here. They're servicing their own fleet. I think there's every reason to believe, based on the dispute between the parties, that they're also servicing other Teslas at the servicing center. So that's all happening. And the fact that all that's happening does underscore that there's no antitrust injury here, because the only injury they're getting is the cost of compliance with the subpoena, and I don't see how that is antitrust injury. But as to the equal protection claim, that at least goes to their real beef. They are not able to directly sell Teslas in the state of Louisiana. That all goes back to that state law. In the district court, they tried to weave that into their antitrust conspiracy and say there was somehow a sham exception to Norr Pennington for the Dealers Association lobbying for that law. That's all dropped. So all they have in this court challenging the direct sales ban is this equal protection claim. And that equal protection claim, after this court's decision in Ford, this court's decision in the international truck case, that just seems to me to be, with all due respect to my friends, just dead on arrival. And there's just, this is not a situation where the state's coming in and saying our rational basis is protectionism. This is a situation where the state is pointing to this court's precedents in Ford and international truck and saying, as you've already said, vertical integration, as a state, we can say that in some industries we prefer that or we allow it, but in others we think it makes more sense to not have vertical integration and to have a dealership model. The Supreme Court confronted the same issue in the Dormant Commerce Clause context in Exxon against Maryland and said, Maryland can make that decision when it comes to retailing gas. This court said the same thing in the context of the retailing cars. So I'm happy to answer other questions if the court has them, but I'm conscious of the time of the day it is, so I'm also happy to yield back my time to the panel.
No, thank you, Mr. Clement. Mr. Holtzblatt for rebuttal.
Thank you, Your Honor. I'd like to start where my friend did with the due process clause issue. My friend pointed to the Friedman decision and the Chrysler decision, but the issue in the Friedman case was that there was nothing. There had been no conduct that had occurred yet in the Friedman case, and so it was just a pure structural challenge to the structure of the commission. What the court says, we need to have the context in which the dispute arises, and that makes sense because it is the context in which the dispute arises that indicates whether there is a pecuniary interest or pecuniary bias that would exist within the commission or not, and it's that action by the agency of competitors that illustrates whether that pecuniary bias exists. Now, that's what we had in Gibson and Wall, and critically, Gibson and Wall had exactly some of the features that we've been talking about today. There were parallel state proceedings in Gibson and Wall, and in fact, the Supreme Court in Gibson addressed a bunch of abstention objections, which my friends on the other side have not even made on appeal, and the court said this due process issue is so significant we need to resolve it right away, when we can look at the very specific context where the dispute arises, and we can see the clear conflict of interest.
Characterize the context here.
The-
You're distinguishable from Friedman. How do you characterize the context that makes you different?
There is an investigation underway by the dealer commissioners who are direct competitors of Tesla and view the direct-to-consumer business model as an existential threat, where they have voted not to, they have voted multiple times against Tesla, including refusing to even adjudicate the fleet owner question, which Tesla says cuts off this case at the outset. And so we see that the context of the investigation is one over Tesla's ability to perform warranty service, where there is a direct conflict of interest between the dealer commissioners who are on the commission and Tesla. Now, there may be, you can imagine other types of actions the commission could take. Imagine the commission says, well, we want to require that all lessors, Tesla's a lessor, all lessors disclose all of the terms of a lease. Well, that would not present the same kind of financial conflict between the dealer commissioners and Tesla that we have here. So we're not saying there are no contexts in which a commission that's organized this way can do anything, and that's really what Friedman's about. It's about saying, we're not going to let you just say in the abstract that there is a commission that might theoretically present conflicts. We're going to look for there to be a specific context in which the dispute arises so that we know, is this the kind of context where a conflict of interest is presented? And it very much is presented in this case because of the context. I'm sorry? Oh. All of what we think we've heard from my friend on the other side is really, were effectively factual defenses. There are claims about how you can interpret the facts in this case differently, and they're free to make those arguments at later stages of the case and to develop their evidence. But what was concerning in Gibson and Wall is that there was a pecuniary interest that would tempt the commissioners to act in a particular way, just as we face with judges. I mean, if a judge has a financial interest in the dispute before them, then you don't wait to see what the outcome of the dispute is. You don't say, did the judge rule fairly? Did the judge get the law right? The fact that the judge has the financial interest creates a due process violation right away, and that's the same problem that we have with the dealer commissioners. Now, my friend also said that this is the only context in which we have agreement that is based on the votes. And with due respect, that's just misreading. I mean, and the court can read the cases yourselves, these decisions in Smile Direct Club and North Carolina Board of Dental. But in Smile Direct Club, the abusive raids that my friend pointed to went to a different element of the claim, which was whether it was an unreasonable restraint of trade. But when it came to whether there was a plausible allegation of an agreement, the Ninth Circuit pointed only to the congruence between the interests of the board in that case and their governance role. They didn't even have votes as we have here, so there was even less in the Smile Direct Club case than there is here. North Carolina Board of Dental was a case that had an entire factual record. We had already been through a trial before the FTC and was being reviewed by the Fourth Circuit, and they pointed critically to there being votes. Now, the Golden Bridge case, which my friend highlighted, and he noted that it was a summary judgment decision, but that's really important because the standard is different at summary judgment than it is at a motion to dismiss stage. At the motion to dismiss stage, there just needs to be a reasonable likelihood that discovery will show an agreement. At the summary judgment stage, you have to exclude the possibility of independent action. And so there was a critical difference in that case. The vote that happened in the Golden Bridge case as well is factually distinguishable. It was not the core part of the claim in that case. Instead, the core part of the claim was that 6 Standard Center members of the board were speaking with each other and communicating with each other, and they didn't even have a vote. So I think the Golden Bridge case is distinguishable. Now, with due respect, we do believe there's an agreement that goes beyond the dealer commissioners, although the vote by the commissioners is sufficient, certainly to survive a motion to dismiss for that claim to go forward here. And we've pointed to classic evidence of an agreement, exchanged assurances of common action. When news broke that Tesla was opening the service center in New Orleans, immediately dealers communicated to the commissioner's executive director and said, this is bad for our business, acknowledging that they had a financial interest in this, and the commissioner's executive director responded by saying, on it, we're on it, indicating an agreement. Now, my friends interpret those exchanges differently, but that is a factual question that needs to be allowed to proceed through discovery. It's not something that should be decided on the pleadings. Now, of course, there are aspects of disagreement that my friends claim exist in.
Not being on it necessarily meaning they're going to do it your way. It just means, you know, we're on it in this case. That doesn't mean we're going to rule for or against you. It just means we're considering this case.
Well, I think the fact that there is now.
On it.
Yes, Your Honor, and I think the fact that now that we are in the situation that we're in indicates that being on it meant we're going to move forward. We're going to address the concern that you've raised. It may be that my friends interpret those facts differently, but we are entitled at the motion to dismiss stage to all plausible inferences in our favor, and that is what discovery is for.
I understand. How does the phrase "on it" mean I'm going to rule for you? If you said, "Well, Judge, I want to make sure you rule on this case," and I say I'm on it, does that mean I'm going to rule for you?
Well, what we know now, there is no dispute about, Your Honor, is that with respect to whether Tesla can service vehicles that have been sold, there is agreement between the commissioners and the LADA, which is that they say Tesla cannot do that. So we have, at least up to that issue, not even any dispute that everyone is trying to stop Tesla from being able to service warranty vehicles. Now, there can be disagreement on the precise ways to effectuate a conspiracy, but that does not change the agreement on the ultimate goal. I see that my time has expired. Thank you, Your Honor.
Yes, thank you, Mr. Holtzblatt. Your case and all of today's cases are under submission, and the court is